I think that there are ways that you could force Ethan to settle. I don't know if these defendants are the ones to make him do it, though. When your case is so bad that law tubers think it won't even make it to trial because the judge themselves is going to throw it out, you know you're in big trouble. Wait, is this guy saying the case is going to get thrown out, or?
Well, they demand a jury trial. However, a judge could grant summary judgment for the Kleins. And this is a case where I think there is a good possibility the Kleins could get summary judgment. It could be so obvious that the Kleins get summary judgment. They don't even need a trial because it's such a killer case.
Isn't this lawyer ass? I don't know if he's a bad lawyer or not.
So
I know he said retarded shit about my case, but he might just hate me. And when people hate me, they say retarded things.
Case. So this is where I think they really got to sweat. The jury might not even save them. Just what? So obvious that the Kleins get summary judgment. They don't even need a trial.
So, okay, so quick memes. When somebody is sued, okay, when somebody is sued, what happens is a complaint is filed, okay, and a complaint will say something like, this guy is an asshole, okay? So, fuck A, okay? A did X, Y, and Z. And therefore, as a result, right, he did these things. These are the facts. And so I'm suing him because of Q. This, like, we'll call it a law, I guess. Some civil cause of action, okay? Once a case is filed, you can put whatever you want in this complaint, okay? So fuck A, he did X, Y, Z, and I'm citing because of, like, civil cause of action Q, all right? Now, at this point, I think there's probably more you can do. I don't know all the civil procedure rules. But at this point, you have a response. And generally, your response is going to be something like, I didn't do X, Y, and Z. Is it this sign? I don't fucking know. I didn't do this. Or I did do this, but there's a reason why, right? Your affirmative defense or something, right? If somebody now, and this is the pleading stage. This is like your opening stage of a lawsuit, okay? If somebody were to say, okay, fuck A, all right, he did X, Y, and Z because of civil cause of action Q. Now, let's say that we look at civil cause of action Q. Let's say the civil cause of action Q is this person, okay, took a shit in your dog's mouth, all right? And you say, fuck A. This guy wastes all of his toilet paper, has diarrhea all the time, and he pissed all over my flowers, okay? Because of what's listed, because of what I'm allowed via, the civil cause of action Q, okay, him. Well, one thing that you could do, okay, on the pleading stage is you could immediately you file a motion to dismiss, okay? A motion to dismiss, okay? What a motion to dismiss must do is it must assume all of the facts in the complaint are true. You cannot contest a fact. There's no factual evaluation, and you don't care, you don't give a fuck about what the respondent has said, the defendant has said about the case. All you do is you basically look at the complaint and you go, okay, well, do the facts stated in the complaint satisfy the civil cause of action Q? Well, you said that he has diarrhea all the time. You said he wastes a lot of toilet paper. You said that he pissed all over your garden. But civil cause of action Q, you didn't actually meet the elements of this. So if this guy were to file a motion to dismiss, this wouldn't survive the pleading stage. It would be dismissed for failure to state a claim because you didn't allege in your fact pattern anything that would satisfy the cause of action Q, right? So this is for a motion to dismiss, all right? Ideally, if you're not retarded, everything should survive a motion to dismiss. If your case gets dismissed on a motion to dismiss, you're probably retarded, or likely retarded, or you're definitely retarded, because it means that you couldn't write you literally can make shit up for a complaint if you want. You can write whatever the fuck you want. You should never lose on a motion to dismiss, okay? past this, you're going to do a whole bunch of other retarded shit. Past the pleading stage, we have discovery, you do, interrogatories, requests for subpoenas, all this bullshit. Blah, 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 blah. At the end of your discovery phase, now you have something called summary judgment, okay? So a motion for summary judgment, this is not ex parte. This is not one side. You don't assume everything here is a fact, okay? You're allowed, as a judge, I believe, I don't know where the strict standard is, but you can take like a gentle look at what has the respondent said and what has come out in the discovery phase about what's going on here, right? So let's say, for instance, let's say that fuck A, let's say that, they said all these things about diarrhea, toilet paper, whatever. Let's say they'll say, my best friend saw him shit in the dog's mouth. She saw him. Well, let's say that as part of discovery, okay? Let's say that as part of discovery. Let's say that I am able to get a record of their text messages, and I get a text message where the guy says to the friend, hey, I need you to lie about this, please, so that I get this case survived, right? Well, the judge will look at that and go, okay, well, this fact is probably not true. This is I can see you lied here. Like, this is going to be summary judgment, means that I'm going to declare the respondent the winner of this case here, right? Or let's say that you have a deposition of the friend, and let's say that the friend says, yeah, I saw you shit in that dog's mouth. And let's say you're like, okay, well, didn't that dog die on July 12th? And you're like, yeah. So what? You said I shit in the mouth when? I saw it on July 10th. And you're like, okay, well, here are my tickets to Japan. And here's like 400 videos of me riding the anime roller coasters. Like, I wasn't even here for 2 weeks or whatever. It's like, oh, shit. And then the guy's like, okay, well, maybe I didn't see you there. Okay, sure, fine, I didn't actually see you there. Whatever, you got me. Okay, yeah, maybe it was somebody else or whatever, right? The factual grounds might be so weak now when you consider what's come out in discovery that a judge could go, okay, well, this is bullshit. So summary judgment for the defense, right? Or let's say that the defense, is saying, okay, I did shit in your dog's mouth. However, your dog was a pit bull, and I hate pit bulls, and I think pit bulls kill children, and I think that they're child murderers. So yeah, I shit in the dog's mouth. So what are you going to do about it? Well, the judge would look at that and go, okay, well, this is not an affirmative defense. There's not a special carve out for murdering pit bulls via shit in mouth. So summary judgment for the plaintiff. Like, you lose. You're not even stating a real defense here. Legally, you have no defense at all. I'm not just going to throw you in front of a jury and let you see if you can, see what happens. It's a matter of law. You've lost the case, right? To survive the summary judgment phase, what you need to have is a material dispute in fact, meaning that both sides are contesting some fact or set of facts, because judges are generally not supposed to do a fact evaluation. So for instance, let's say that you have 3 witnesses that you depose on 3 witnesses that saw the defendant shit in the dog's mouth. And let's say the defendant says, I didn't shit in the dog's mouth. I wasn't there at all. Fuck you. You depose them. You go back and forth. They hold on to your testimony. Now, both sides will file for summary judgment, because you always do, because, fucking, why not? However, the judge will probably say, well, we've got 3 people who are contending that you did shit in the dog's mouth, and you say that you didn't. This is a material dispute in fact. That's not appropriate for me to decide in a summary judgment phase. We have to move on to a trial, right? A trial is where both sides are now putting their credibility on the line, and they're telling what they feel is the most convincing story possible, with character witnesses and with evidence to demonstrate their story. And then it's up to some, third party to look at that and go, well, who do I believe more? Who's more credible? Who's presented better evidence? Who do I trust more? And that could be either a judge in the case of a bench trial, or a jury in the case of a jury trial. That's basically, I think this is basically like, yeah. Now, as for what counts as a material dispute in fact, I've heard that things can be like, I've heard that this can depend on the judge. So like, for instance, so for my case, right, the scariest thing, or the most annoying thing, or whatever you want to call it, is there's a person claiming that I sent them something. I haven't sent them anything. That's not in my logs anywhere. They said that I did to a friend, and they're saying it to the plaintiff, but I say that it didn't happen. So I think that's like an edge case where a judge could look at that and go, well, the plaintiff here, your witness hasn't provided any evidence of this thing actually happening. So I don't think this whole case is going to go to trial because of this. So in that case, the judge could grant summary judgment for me, right? And say, well, there's no evidence of this. It's failure to state a claim. Basically, you have nothing here. Or I think if the judge is less liberal, more on the conservative side, I think a judge could say, well, even though they haven't necessarily given hard evidence of this, their testimony is in and of itself evidence. And it is, right? Somebody saying this person sent me a video, that is evidence, right? That's their testimony. And a judge could say, I don't decide that. That's up for a jury to decide, basically, right? So these are, I don't know if there's like a, Destiny misstated the standard of review for SMJ, subject matter jurisdiction. I don't know if we're talking about that right now, but yeah, I don't know what I don't know if there's like a hard line for how judges decide what counts as a material dispute in fact or not. Like some things clearly are, like we've got strong testimony that's alleging like different things happened regarding the same set of facts. And I think some things might be a bit hazier, where maybe a judge could go either way. SMJ equals summary judgment. Sorry. Oh, what is the standard of review? Can you explain that for me, or can you link me a Westlaw or something? I'm curious. Maybe it'll make me feel better about my case if you link me something good here. It's just to view the facts in the light most beneficial to the non-movement. Oh, interesting. Okay. So most beneficial doesn't mean that you necessarily have to like assume it is true. It's not as strong as the, like on the pleading stage, you're not viewing them most beneficially. You're just viewing them as 100% true, right? Or is most beneficial like the most leeway you can give to something? I don't know if that makes sense or not. All that to say.
And this is a case where I think there is a good possibility the clients could get summary judgment.
I don't know when it comes to doing affirmative defenses like fair use. I don't know if that's considered a legal dispute or if that's considered a factual dispute. I have no idea. Is fair use usually decided on summary judgment or by a jury? I actually have no idea. Judges are characterizing factual issues. Oh wait, this is a opinion piece. Constitutional conflicts in deciding fair use on summary judgment. Issues of fair use in copyright cases today decided as pure issues of law. Ah. See, that's why we look shit up before we make strong statements. Good job. Okay. Ooh. Okay, so if I understand that to be true, if the writer here is correct, that means that this will almost certainly be decided in the summary judgment stage, right? Because there's not going to be any material dispute in fact here. Everything is public. All the videos are online. So this is basically just going to be a debate between you and another party with the judge moderating. And the judge is almost certainly going to be... Wait, summary judgment is a high bar to reach. Why are people doing SMJ for summary judgment? I thought SMJ was abbreviation for subject matter jurisdiction. Why do you guys keep doing that? Is a high bar to reach. LawTuber is Wilden? Wait, how is it a high bar to reach? Yeah, like I don't even know if it's purely a debate about fair use. I don't even know if it ever would go to a jury trial. It's going to be... Didn't Ethan ask for trial by jury in his document? No, I thought he asked for trial by combat. Yeah, I mean, I think you can either request a trial by jury or a trial by judge. But this summary judgment isn't even a trial by judge. It's deciding things before the trial phase, technically. Judges don't like granting summary judgment. It's easy to get overturned. I can come on and give a longer explanation, but judges generally don't like it. Really? I thought judges generally like it when they can do it because trials and everything are so time consuming. Like my guess is there's probably a lot more summary judgment awards than actual like goes to trial things, no? Would be my guess. Could Ethan tax evade by donating $100K to each of their GoFundMe pages and then instantly winning it back? Are court judgments, are judgment awards considered taxable income? In most cases, judgment awards and lawsuit settlements are considered taxable income unless they fall under specific exemptions outlined by the Internal Revenue Code, particularly IRC Section 104. So no, that wouldn't work. Although maybe you could theoretically structure your income by donating to their legal fees and then getting a judgment over a period of years. Well, will this be like a very complicated annuity? This is retarded, don't do this. I am very curious, I guess, how many fair use cases go to trial versus are just awarded at summary judgment. Feels incredibly hard, if not impossible, to accurately measure in a service-based economy, though. No, it's actually super easy. What do you mean? You buy and sell services the same way that you buy and sell goods. It's very easy to measure a massage therapist's productivity the same way that it's very easy to measure, you know, a widget salesman's productivity. If a massage therapist, you pay them $50, you know, for an hour of work, and they sell $100 worth of services. I don't know if is your productivity just 2 or what? I don't know how they actually like what units they express it in, but this was my beef with the former lawyer orbiter of DGG, by the way. Jesus Christ, Dan. Instead of a statement like this, which is shared by most lawyers, he instead wanted to focus on motivations. It's fine, I know what's going on. Sucking up to an audience, snark slash Hassan, but you instantly lose my respect. Okay, Jesus. And what was the response here? Hey, Dan, I found someone who was using weasel bullshit language about the strongest infringement case in the history of the world. Maybe you can add them instead of something like a little bitch.
Now, that does not mean Ethan Klein will ultimately prevail. Ethan Klein may very well lose this case. Now, we've said, hey, doesn't look good for Hassan's orbiters. It's looking kind of bad for Hassan's orbiters. I think, in all fairness, the odds are on Ethan here, but they're never 100%. There's always a chance that your orbiters can prevail, whether individually in individual cases or separately. Maybe one of them prevails and the others don't, or maybe all of them prevail. It's possible. It's not 0% chance. Ethan is not 100% going to win.
Listen, I don't want to get in between these guys fighting, but Pisco's statement here is fucking retarded. It's not weasel bullshit, and Pisco knows this as a lawyer. It's not weasel bullshit to say no case is 100%. Bro, you could kill your white wife and leave so much evidence behind and still theoretically have a jury let you off the hook. If you were a famous sports star. Like, I wouldn't even say legal mindset. I wouldn't even say he's hedging here. He's just giving this. It's just always is the fact of the matter is that nothing is 100%, right? Isn't he saying that because Dan accused him of doing weasel bullshit in the second picture? Probably not fair use. Is it even, I know we can mention your strength, but I literally state multiple times in my post on video that I agree that the videos are infringing. I say that it is probably not fair use and the complaint is likely not dismissible. Well,
now that
legal mindset is from the 3 clips I've seen of him, so maybe he's given a much different opinion of this. But legal mindset statements here make it seem like a 95 to 98% win. But like anything can happen, right? I mean, anything can happen. Even in front of a judge, anything can happen. Pisco is saying here, I literally say multiple times in my post in my video that I agree that the videos are infringing. I say that it is probably not fair use. That makes it sound like a 60% win, and that the complaint is likely not dismissible. That just means that the complaint would survive the pleading stage. That's nothing. Remember, you just have to be not retarded to survive the pleading stage. So the statement here is not even remotely comparable to the other one, I think. Probably not fair use is a correct statement. In my stream, I use stronger language. That said, there are plenty of examples, including bootlegging, which would be more clear-cut, not fair use, regardless of how safe it is. Yeah, Dan goes way too hard of like, I can't even possibly think of a single case where it would be more clear-cut. It's like there's a billion cases where it would be more clear-cut. The internet stuff is very weird and is in a very weird spot where there's just not, I don't think there's very many cases on it. There's not much case law. I just said the same thing. I would never say anything on the internet is like 100% clear-cut. It's the bullshit. The Matrix probably isn't real. You probably can't shapeshift into a dinosaur. The world probably isn't filled with a cheddar cheese molten core. This case deserves a stronger statement. They are fucked would suffice. Suffice. It's suffice, right? I always ask this. Unhinged. It's not a euphemism. It's a reflection of the inherent unpredictability of lawsuits, and fair use specifically, where all we go on really are case law analogies. Sorry if you were triggered. I didn't use your magic words though. I don't even think this. I mean, like Pisco's statements here aren't even generally the issue. I think the main weird thing is just how much he's like in the mud on Ethan's like motivations. I guess that's like the weird thing. I think. But what is this?
Finally, on the Ethan Klein lawsuit stuff, just to reiterate with all of you, I will be fighting this lawsuit. I have legal counsel. They are actively working towards drafting some stuff. I can't really share more than that right now, but I can't really share strategy right now, but they are working tirelessly for this case. And I can assure all of you that all of this is going to directly fund the paperwork, the documents that are currently being worked on that will be filed. And I'm very excited to, once it is filed and once it's public, to share it with you guys. So yes, very, very exciting stuff. We are going forward, and we will be working. Finally, on the
Remember, arbitration. Is it arbitration? No, mediation. Is it mediation? Settlements. Settlements can happen at any point in a lawsuit. There's no shot that Denims can say right now for sure whether or not anything will be settled. She has no idea. If the case looks really bad for her, she would probably want to settle. I don't know if Ethan will want to settle. I imagine he'd want to settle. I don't actually know how much money Ethan has or how much money Ethan wants to spend. But like, I think there are worlds because of Ethan's community and because of who Ethan is and because of the people he's surrounded with. I think that there are ways that you could force Ethan to settle. I don't know if these 4 defendants are the ones to make him do it though. Like, if Denims and Frogan and Kaceytron and Sean DeBlack, or if any combination of them, were to say publicly, we feel like this was wrong, we understand this was a mistake, we probably shouldn't have done this. We also think that we've gone really hard on Ethan. We'll continue to fight the lawsuit as best we can, but we understand, we acknowledge we've made mistakes, we've done wrong. We're willing to, make right or make amends in whatever way possible. If they were to come out with public statements like that, even if Ethan decides that he wants to go as hard as possible, I think his reputation would start to become so obliterated that he would settle. He would be forced to settle because the people around him would start to feel uncomfortable. His community would probably start to feel uncomfortable. And then other communities that pressure people around him and his community would start to feel uncomfortable. But the question is whether or not any of these people are capable of deploying that kind of self-awareness and I don't know, I wouldn't call it manipulation, but yeah. Do you think Hassan will help at all? No. Hassan only moves upwards when it comes to clout. And if Hassan thinks that you are a liability, he will instantaneously eject you and not look back. And yeah, so there's no show. Oh, I don't think he will. Unless, and before he said yesterday that he wouldn't. I haven't seen it yet, but I would be surprised if he did. You know what? Hey, if he does publicly help them and tries to fight or whatever, I would be impressed. Because in my mind, Hassan is very much like a Donald Trump figure. He will never take on a fight that isn't already 100% won and then, claim to be fighting on the side.